Good afternoon, everyone. I'm just letting people trickle in for 30 seconds here. Okay. All right. It looks like everyone's in. Good afternoon. My name is Michelle Nadeau. I am the Legal Education Director for the Labor and Employment section of the Florida Bar. We do these monthly webinars as part of our section membership, so we can keep you guys all updated on what is going on in the law. And today we're going to talk about the updates to the state rules of civil procedure. Next month on February 19th, we are going to be discussing expanding intercultural skills to resolve today's increasingly multicultural disputes. So that's going to be about dispute resolution, mediation, and that's going to be with Lynn Cole. And then on we've got another whole day webinar coming up on March 5th. It's going to be litigation skills and technology. This is rescheduled from an in-person event that with the hurricanes didn't end up happening, but it's going to be online now. You guys can do it from the comfort of your office or home, get a whole bunch of credits, hear from some good speakers. It's going to be on March 5th. And on April 24th and 25th will be advanced labor topics. That's going to be and Duck Key. So that's going to be a nice location to go to. And we're gonna have some great speakers there. The registration for both of those events will be open soon, but mark them on your calendars now so that you can attend those. But today we're talking about the rules of civil procedure in state court, and I have the honor of introducing Pete Sartes, a fellow Clearwater attorney here. Pete is a trial attorney. He practices personal injury, nationwide practice. He is much better introducing himself than I'm sure I can do. But he, prior to becoming a lawyer, he served in the United States Army. He got his finance degree, his MBA, and his JD from University of Toledo, and he is very proud of his serving the Greek community here in Pinellas County, and he is going to tell us about all the changes and how it's going to affect our practice.
Thank you, Michelle. I appreciate it. Hi, everybody. Let me just start by putting a couple ground rules that will, I think, make this a lot easier to go through. We've got 50 minutes, which is really not a lot of time for as deep as the changes to the civil rules are. What I will tell you is this: you should see on the bottom of your Zoom, the Zoom link, it'll show you a question bar. There's a chat queue. Open up the chat queue. If you have questions while I'm going through this, it is easier for you to ask the question while we're kind of in the topic area. Chances are you'll be in a place where it all makes sense. And if you have a question, chances are other people will have that same question, or it will be relevant to them too. So please, if you have a question, throw it in the chat. I'm keeping an eye on it so that I'll be able to answer those questions. I am going to share my screen. And you should all at this point be able to see a memorandum that is actually dated for November 15th. I have put together a list of all of the changes to the civil rules that came into effect on January 1st of 2025. I will tell you, these are not minor tweaks. These are significant changes. Most of you, I understand, practice in the employment law world, so you're used to federal court. A lot of this will be reminiscent to you as what we see in federal court. So I have this memorandum. It's about 6 pages long, and it outlines all the changes. I have provided this to Amy, who is our Florida Bar liaison. Anybody who wants a copy of this, it is yours. I'm happy to give it to you. Send it to whomever you want to send it to, and use it as you wish. Let me just check the chat because I'm seeing things happen. Oh, there is a CLE number. That CLE number is 8901. So you probably should make note of that if you want to get credit for this. I will announce it again towards the end of the presentation. That is the number 8901. So with that, you should be able to see I've shared my page with this memorandum. And let's kind of go through this. I'm going to do it the only logical way I know how is to actually go by the rule numbers, starting from the just numerically going down. The biggest change for the courts is going to be this case management pretrial procedure rule changes. Now Rule 1.200 and is a far more structured and proactive approach to case management. You're going to be seeing these in every case that you file. And again, those of you that practice in federal court, you're used to this. You're going to be making an election, whether this is a streamlined case, a normal track, like in federal court, we call it a track 2 case, or if it's complex litigation. Streamlined cases are basically simple issues, trials no more than 3 days. You get a year in order to get that case from fruition to trial. The majority of us will most likely be dealing with general track cases, which is standard litigation, 4 to 5 trial days, maybe 2 weeks at most. You get 18 months, and complex cases are proceeding under a different rule, 1.201. But regardless, those are the big heavy lift cases. I don't do any of these. Some of you may, especially if you're dealing with multiple class actions of employees that may be related. I shouldn't say related, may have related claims against a specific employer. You may be doing complex litigation. We'll talk about that in a second. So what's going to happen? The chief judges are going to have to make an administrative order for each one of the judicial circuits that sets forth how we're going to play this game. I've had a couple cases already since January filed. I have not yet had a case management conference with a judge on a post 2025 case because it's just they're not ripe yet. It takes 120 days of filing to get one of the assignments. But what I am seeing is a lot of the local courts, a lot of your circuits are actually putting a new rule in place that says something like this. If you file a complaint, you also have to file this case management order with your complaint. It's got to be served with the complaint. It puts the other party on notice. They're putting together case management orders that pretty much are standard except for the date of the trial. And then once you put the date of the trial in, everything kind of trickles down and will populate for, you got 90 days to this, 120 days to do that, 6 months to do these things, so many days to do mediation. This is going to be exactly like we deal with cases in the federal courts. And I will tell you, for those of you that may be a little, let's just say, lackadaisical about your litigation, or for those of you that know opposing counsels that are lackadaisical in their litigation, this is going to be important to you. Why? Because once these dates and these case assignments get set, they are set in stone. You as the parties, you as the litigants, do not have the right to change these dates. You have to get in front of a judge. And even if the two of you agree to an extension of time, that's not enough. You have to have a court order that says that you're allowed to change a date. So I'm not telling you that there's no way to get dates changed, but you're going to have to get in front of a judge at some point if you want to change something. And you're going to have to explain to that court why it is in the interest of justice. So I'm just telling you, we just haven't gotten there yet, Judge, is not going to work 2025 going forward. All right. There are going to be deadlines for the service of the complaints, adding new parties. All that stuff is in the case management order. There's going to be alternative dispute resolutions. I'm not sure how many of you have seen this, but for me, I'm seeing a lot of circuits go to mediation, non-binding arbitration, and then litigation. All that stuff is going to be in the order. Let me show you right here, which is what I was talking about regarding the enforcement of deadlines. The enforcement of deadlines are court order and not by the agreement of the parties. So it's a big deal. Keep an eye on this or you will screw yourself up. And if it works out the way I'm expecting it to work out, it may not be as stringent as federal court when any of our judges would say, so you didn't provide the discovery timely? Yeah, well, it's out. You don't get to use it during your litigation. I think our state court judges will be a little bit more lenient, but you better have a darn good reason why things didn't happen timely. Complex litigation, I'll be very honest about it. I don't do it. So I'm not really keen on how this is going to affect you, but there are going to be hearings that are part of this complex litigation that gets set for. So you will have like maybe 4 hearing dates just because. And the judges are going to reserve that time so you can get in there and actually deal with issues that you have to deal with. One of the big deals on this is if you have those preset hearings or predetermined hearings in place and you're not going to use them, I'll be very clear where I am. Parties must notify the court that you don't need it, so they're not keeping these dates for other people, in cases where other people can use them. So just be aware, if you're in complex litigation and you do find yourself marking on the court's docket over the course of a year or 18 months, on these specific dates, Judge, we are blocking off an hour, 2 hours, a half day, whatever, for specific hearings. If you're not going to use them, you must notify the court so you can release those dates for other people to be able to use. Continuances in complex litigation are going to be a little bit different. There is strict compliance for them also. So just take this with a grain of salt. You need to be proactive. If you're not going to be able to conclude discovery in a particular amount of time, when you figure that out, because you have too many witnesses, too many, whatever the case may be, too many issues that require court intervention, you need to let the court know so you're not in a place where the court's looking at you, trying to figure out why you've just figured this out at the 11th hour. If there's no questions specifically on the case management orders, let's get into some of the meat. This is a big deal. And again, very federal prompted rule change. In every motion that you file, you have to put a notice in the pleading that you have had a good faith effort to resolve the issue. There has to be a certificate of conferral in your pleadings. What my law firm has done is we've actually added this to our motion template. So every time somebody in my law firm wants to file a motion, it can generate a pre-populated document that has the case file and all those things in it. And it automatically will add this to the bottom, indicating that you have contacted opposing counsel, attempted to resolve the issues. And if you cannot resolve those issues, you indicate what those issues are. And that's kind of the important part, the little distinction about what the federal rule says and what the new state rule says. Let's just say you get a motion to compel or a non-party subpoena, and you are willing to agree to A through C, but you don't agree to D and E. What you're supposed to do is indicate to the court, we have confirmed with opposing counsel, we agree with A, B, C, we cannot agree to D and E for these reasons. You've actually got to put the reason in the pleading so the court knows exactly what your issue is. The purpose of this is to kind of narrow it down. A lot of jurisdictions, meaning a lot of the circuits, are having local rules put into place that deals with discovery and things like that. And the courts may not even have a hearing on some of this stuff. They may just say, as a matter of course, we're going to allow medical records for 5 years, let's just say. That's just going to happen. The courts can issue an order, and then whatever's left over, presuming there is anything left over, you'll have a hearing in order to be able to obtain your relief. But the most important part of this change, I'm going to reiterate it, is you have a duty to confer. That duty to confer has to be in your pleading, and you have to have a certificate that you actually conferred with that party. One thing that I did find that's going to be an issue, you know how sometimes you have that opposing counsel, you reach out and like, hey, can we talk about this? Maybe 2 days later, you send another email. Hey, counsel, can we talk about this? Still nothing. A couple days later, you're just going to file. After 3 attempts, you're going to file your motion and you're going to put in that certificate of conferral that I contacted opposing counsel on A day, Y day, and B day, and they never responded to me. The courts are going to be considering that going forward. Discovery. Guys, I cannot stress for you, you should probably take a minute and go read 1.280 if you're not going to just go ahead and read my memorandum. There is a lot of changes in discovery that will make your lives miserable if you do not prepare yourselves from the front. First of all, proportionality. You can't just ask for everything and anything under the sun as a fishing expedition and say, well, Judge, it may at some point lead to discoverable material. No, the request that you make is proportionate. It has to be proportionate to your litigation. I do have a question. Give me a second. Let me see if I can answer this now. For motions to compel discovery, is it okay to consolidate the certificate of good faith and certificate of conferral? No. And the reason I say no is because in 1.220, it actually has two separate and distinct components. So for me, I have a line in my motion that says, we have conferred with opposing counsel, and here is my signature block above my certificate of service that says, I've conferred with this date and this time with this person, and these are the issues that we have. I think one is a line item in your motion that says we've conferred with opposing counsel, and the other one is an actual certificate which you have to sign. And I've put that certificate of conferral in the pleadings right above where my certificate of service is. I'm not saying that's the only way to do it, but that is for sure covering the bases because the rule specifically says two central components. I hope that answers your question. And if anybody finds out any different, I mean, listen, I'm not saying I'm the end all and be all in this. The circuits are going to the law will kind of filter its way through your individual circuits. So you may find that this is duplicitous. I may figure it out too, but that's going to, come over the course of practice. But for right now, I would do both. All right. Going back to discovery. You got to know what you're asking for. And for us as personal injury lawyers, I put my client's medical health at issue. So I don't think I'm going to have a lot of argument to say, well, Judge, they're asking me for 10 years of orthopedic records if my client broke his arm. But I think I am going to have a lot of meat when they say, Judge, the defense is asking for my client's gynecology records from when she was 18 years old. She is now 72, and this is a broken leg case. And I think we're going to see that the courts are going to allow a lot less latitude because the request has to be proportional to the causes and the defenses. So just be in mind that that's going to be something that is going to be a big deal. If you get nothing out of this presentation today, write this down. Everybody, and I mean everybody, now has an obligation to provide initial disclosures just like in federal court. So let's talk about this rule 1.280A. What you have to provide within 60 days after service of the complaint or joinder of an additional party, plaintiffs, is the name and contact information of anybody likely to have discoverable information. These are your witnesses, your doctors, potentially your experts. A description of the documents and tangible things, now this is important, that may be used to support claims or defenses. So you have to turn over not only your client, I mean, for my purposes, my client's medical bills, medical records, photographs of the crash, all that stuff. For your purposes, employment agreements, any documentation regarding any issues between the employer and the employees. But you've also got to be mindful of things that may be relevant to the other side for their defense. The defense, I believe, based on this, is obligated to provide to you any information that may be relevant to you in support of your claim. I look at this kind of like Brady discovery for all of you that have done criminal work in the federal system. The prosecutor has to turn over anything that may be exculpatory to your client. I believe the defense has the obligation to provide you anything that may very well support your claims. And I think you may have an obligation to provide any documentation that you know of that may well support any defenses. You now have to compute your damages. And I should have put this in here, but I didn't, so I apologize. That is economic damages, not non-economic damages. So if you have lost wages, compute them. If you have pain, suffering, inconvenience, compute them. If you have loss of ability to earn income, compute them and how you get them. This is in your initial disclosure. And finally, any insurance agreements that may satisfy all or part of a judgment. Honestly, I think for most parts, this is going to be more the defense filling this part out, unless you have insurance that covers you. For example, you have some sort of insurance that may mitigate your damages. This is going to be not in a pleading, but it is going to be in a document you provide to opposing counsel. As you know, you do not file discovery in state court or in federal court. So just be aware that you have to do this within 60 days. What we're doing it is before we file a lawsuit. Any lawsuit has to have this stuff put into play. So as soon as my lawsuit gets filed, the minute I get a answer or a notice of appearance from opposing counsel, they're getting this. I think it will prepare your case better if you do it up front. And I think that is the intent of this rule change, is to make sure that you've got your ducks in a row so you're not filing lawsuits willy-nilly and then we'll figure it out when we get there. You better figure it out now because you're going to have to provide this information. The next real important part is some of you and some of your opposing counsel have probably taken the position that, Your Honor, I am only obligated to answer discovery that is provided to me at the time that I get the discovery. So if you do an interrogatory, I provide you the answers in the interrogatory, I provide you the answers in the request to produce, but I'm not obligated to update those. But you are now. So you now have a duty to supplement your discovery as things happen. I got a question. Do you suggest generally referencing non-economic damages and to be determined? What about attorney's fees? Here's what I suggest for non-economics in 1280. I would put in your economic damages, outline how you think you calculate them. When it comes to non-economic damages, I'm using, and again, because we do personal injury work, I use to be determined by the jury. That is going to be my clincher. In regards to attorney's fees, I think that you have to put something down on attorney's fees that says, and I'll make it up, the employment agreement has prevailing party attorney fees listed. Therefore, I will be seeking attorney's fees consistent with the agreement at a rate of $600, $800, $400, whatever your hourly rate is, whatever you think is reasonable, so that you're putting the other side on notice as to what that attorney fee calculation is going to be based on. So that is how I would do it. Again, I'm not saying it's the only way you have to do it for non-economics, but that's how I would do it. So, that's my plan in my cases. Think about what you're doing. This is now a duty to really put the other side on notice, to really vet the issues. So we're not going to court and arguing with the judges or arguing to the judges. Well, judge, he knows I bill $500, $600, $700, $800 an hour, so this shouldn't be strange. This court's already approved attorney fee and costs, attorney fees for my cases in this dollar amount. Put it in there, put them on notice. Back to duties of supplement. So this has to supplement when material becomes available. So once you learn that particular information has come up, you're obligated to provide updated discovery notices. And here's what I'm doing. Again, PI versus employment law. As I learn of additional treatment, as I learn of additional bills, as I learn of additional causes of action or documents, it comes into my office. I will do a notice of supplemental disclosures. Now, let's just talk generally about your interrogatories and request to produce. Something that we're doing in my office is we would normally send out standard discovery, in personal injury cases. And that standard discovery, I think, is a little redundant in some forms because of this. So we are retooling our initial disclosures and our initial discovery to take out these things. I'm no longer asking for the names and contact information of individuals likely to have discoverable information. What I'm saying now is, in addition to initial disclosures pursuant to 1.280A2, here are the additional interrogatories and requests to produce. And I'm doing that purposely so opposing counsel knows I'm expecting reciprocal discovery, and I'm expecting you to tell me the names of likely individuals. I'm expecting you to tell me about computation damage, descriptions of documents that may be relevant. But in addition, I'm also doing standard interrogatories and requests to produce. My logic is, why waste a question? Keep it in your back pocket. There's no reason to ask for these things anymore because they're obligated, or we are all obligated to provide them anyway. So save the question and use it for something that may be important in the future. ESI. Let me take a look, see if there's anything here. No, seeing nothing. ESI, electronically stored information. There is an amendment that allows the court to limit the frequency and extent of this kind of discovery. So it's not going to be any and all every time. I don't really deal with a lot of this. Most of the time, the things that I deal with are, specific batches of electronically stored documents that are relevant. It's probably going to be far more relevant to you all in the employment world because you're going to need the correspondence, the emails, any, documentation, any, adverse actions that were discussed about a particular employee. I can see that being important in your cases. I think you have to be cognizant about how you ask for it now, because it's not just going to be a cumulative, duplicitous request for any and all every time. Take it with a grain of salt. Just read that. I don't think it's unclear. I just don't know how it may relate to your individual causes of action and what you all are doing. Okay. A big deal again for us in the civil world, general civil, and in personal injury. In the old days, we would have to file a motion that says, or a notice to the court that this issue is now at trial, now at issue for trial, in order to get on the trial docket. And there was a bunch of ways to do this. Some people, some plaintiffs' lawyers would just file this the minute they got an answer from the complaint and say, all right, we are now at issue for trial. Let's get a trial date. I would do it kind of after discovery was done and I knew what this case looked like and I had a good feel for what my case would look like. I would then file a notice that the claim is at issue. Why? In order to get an actual trial date on the docket. You don't have to do this anymore. Not part of the plan anymore. It's done. What will happen is you're going to have um, a case management order. That case management order is going to fix the trial period. And that's going to happen for you. I think when you do your conferences with your opposing counsels to determine when you're going to try a case, I think you've got to be more astute like we do in federal court. And I'm sorry that I keep bringing that up, but the similarities are so uh, obvious to me that I think it's the easiest way to say it. You got to look at your case and figure out how long it's going to take you to try it. Figure out how many witnesses you have. And I make this comment because I've had this argument in front of a judge. When I get a witness list from defense with 35 people on it, I'm like, Judge, how are they going to get 35 people to testify in a 2-day trial? That's not possible. You're going to have to start thinking about things and really making a cognizant effort to really put your trial case management order in a place that actually makes sense. Don't end, and I'll give you an example, have expert discovery due 30 days before a trial when you know there's no way you're ever going to be able to get that discovery, process it, get the defense expert or the plaintiff's expert listed for trial, set for deposition, and then have their brochure and all that stuff done within 30 days. It ain't going to work. So since you know it ain't going to work, don't put yourself in that position. And don't let the defense, excuse me, defense lawyers out there, I apologize. I'm a plaintiff's guy, no offense. You can't let them push you into like, we'll figure it out. Just put these general timeframes in. Because plaintiffs, you're going to get screwed. When the court says, well, Mr. Plaintiff's lawyer or Miss Plaintiff's lawyer, you agreed to this. Why did you agree to this if you didn't think it was possible to be done? Because now remember, it's your obligation to go to the court and explain why you need these orders and these dates changed. So don't put yourself in that position. Realistically, think about it. And what I do, thanks to my military training, is I do something called a reverse timeline. I know when my trial is. I know when I have to have my exhibits in. I know when I have to have my witnesses deposed by. I know when I have to have all that stuff done. So I do it in reverse order. And that's why I know there's no way I can do this in this amount of time because there's just not going to be enough time. So think about it. Those of you that have tried cases, be conscious about it. For those of you that haven't, you're going to have to reach out to some of your colleagues that have tried cases and talk about this stuff because ultimately, there's kind of a balancing act of how the timeline of events works, and you don't really get a good handle for that until you've actually tried a case. Hold on. Timing of the pre-trials. A lot of these things are going to be set in your orders. So, 30 days out, there are going to be pre-trials. There are going to be cattle calls in advance to figure out who's going to trial. All those things will be in that case management order. Don't worry. Everybody okay so far? Not seeing any additional questions. I'm going to continue. Motions to continue trial under 1.460. Read this and take with it as you may. Continuances are disfavored. The amended rule states that motions to continue trial are disfavored and should rarely be granted, and then only upon good cause shown. This is to discourage unnecessary delay. So I guess what I'm getting at is, while you're setting your trial order dates, understand that the courts are not going to be letting you continue your trials just because you just didn't have time. You better have a better answer. Have a question. Since the initial disclosures rule says the disclosing party must make disclosures, it may use to support its claims or defenses. Does case law provide that the disclosing party should also disclose information that supports the opposing party's position? Great question. I have not seen any case law that has developed yet since all this took effect 29 days ago. I think that you're obligated, obviously, to protect your client's interests. But if you know that there is a document in your possession that is not good for you, but it's a document that was conveyed between the parties, you can't just sweep it under the rug. I think you're going to have an obligation to disclose it. And I think if you don't disclose it and somewhere later in discovery it comes up that you knew about this document and you purposely made an effort to not provide an initial discovery, you're going to get sanctioned with fees and costs for all the time it took the other side to prepare because you didn't provide that document. I think that is going to be very real in state court. This question is great. What do we do about old cases where there is no case management order setting discovery or their deadlines? Aha. Great question. The general answer is this. The rules of procedure are, by their nature, procedural. So as of January 1st, all of your cases, even though they may be older, are now using these rules of civil procedure. So the substantive law that you use is the law in play at the time when your cause of action accrued. The procedure goes at the time when things are happening. So for those of you that have filed cases prior to 2025, understand these rules are going to be applicable to you. It may be a good time to, have a hearing with the court, especially those of you that want to get those cases moving and say, all right, judge, we got the new rules. Let's get this case set for trial. Let's get some, an actual case management order in place so we can make this work. That's what I'm doing with my cases. Again, I'm a plaintiff's lawyer, and it is my habit to make things move forward because sitting around doesn't make your case more valuable. So I am getting people in front of judges, and at this point, and I've done this across the state a few times. I've done this across the state, and the judges are very receptive to it. Like, all right, Mr. Sartes, what do you want? Judge, we have the new rules. I know this is no case. I want a case management order so we can get this thing moving. And the judges seem to be responsive to me, and I'm getting cases moving. So take it for what you will. Let's talk about documents marked confidential. This is a question. If the documents would have been marked confidential under the standard confidentiality agreement, can you reserve production until such an agreement is in place? Yes. I think what you need to do is say this. There are documents that are subject to confidentiality. These documents will be disclosed as soon as a confidentiality agreement is executed. A mutually, agreeable confidentiality agreement is in place by both parties. That is the language I would put in there. That way you've disclosed that they exist. It's in your initial disclosure, and you put the onus on the other side to make sure they get with you to get the confidentiality details worked out. Very good question. Yes, I think that you don't have to disclose confidential information until that document is in place, but you have to disclose that they exist. Woo, all right, let's move forward. Motion requirements. A motion to continue a trial must now be in writing. No more sua sponte stuff. Signed by the named party. I'm going to say that again. Signed by the named party requesting the continuance. Doesn't say signed by the attorney. Named party, and filed promptly after the emergence of grounds. And it's very, very specific, almost like in federal court. The basis of the need, whether the motion is opposed, the action specify dates that will enable the movement to be ready for trial, and the proposed date by which the case will be ready for trial. The reason the courts, excuse me, the reason the committee put this into play is because your clients need to know that you're continuing trials and why. So the judges now want to see your client's signature on the bottom of that page, so they know that I should say it this way: the judges know that the party is aware of the continuance and all these reasons. So take that with a grain of salt for what it may be, but you're going to have your clients notified. Another question. Under Florida Rule of Civil Procedure 1.280F, a party may not seek discovery from any source before the party's initial disclosure obligations are satisfied. Does that mean that we should object to discovery that is served with the complaint and should have a due date before the initial disclosures? That's a great question. I still am going to be filing my discovery along with my complaint. That way I know everybody gets everything. But I think at this point, that's a point well taken. Initial disclosures are going to come out within those 60 days, at which point then there's going to be an opportunity for discovery to happen. It's up to you whether you want to file a motion to stay that discovery, or a motion to to dismiss that discovery is not ripe yet. I don't know, but I think you're probably be better off from a purposes of time standpoint. Is you haven't given me your initial disclosures, boss. How am I supposed to give you discovery? So that is my intention. That is how I am going to work, and that's how I think you all should. I think if you're prepared for me, I'm going to send my initial disclosures to opposing counsel the minute they file their notice. And that's just the way I'm going to operate, because I want to keep the ball moving. So for plaintiffs, that may be the way to go. So it keeps this process moving forward. An additional question: if rules apply to pending matters, should it be sending initial disclosures in all cases that are already running? I am actually sending updates. So as I get additional materials, I am sending additional material. I presume that if you're in litigation for the last 2 years, you have provided initial discovery by now. If you have updates, you need to provide those. I would take that stance, because I think that is going to be better served if you do it that way. Unless, of course, you want to take a procedural stance on this and you want to get it appealed, just so you can get in front of a judge and see what that judge is going to do. So, I mean, now is the time to do that stuff, guys, because I don't think the judges are going to take your pre-2025 cases and throw your discovery out if you haven't updated it. But I think there's going to be discussion that say, come on, counsel, these are substantive, you have to comply with them. Let's get that update happening. So you can, if now you want to appeal it, now is the time to at least test the waters and see how those judges are going to rule. But for your new cases, yeah, you got to have additional disclosures out. Let me get one more comment. I believe it's 40 and not 6 days for the response under 1.510. You very well may be right. What I put in here for 1.460, get back. On 1.280 is what's actually in the initial disclosure statute. It says made within 60 days. Made within 60 days. That's why I picked it. If 1.510 has a different date, do with it as you will. I believe the civil rules folks tried to make this consistent as best as they could. So again, take this with a grain of salt. Is there an approved form that has been adopted for initial disclosures? No. I am using the actual form I use for federal court, and I'm just outlining this right here. I'm saying initial disclosure, case caption, initial disclosures by plaintiff, pursuant to 1.210A2, and I say 1, information, 2, information, 3, computation of damages, 4, my client has personal protection, for my car accident cases. That's what I'm doing. I love it when you guys participate. It makes it so much more fun. Let's get back to this fun thing. Dilatory conduct. We used to joke in my business that the defense's job is to confuse and delay. Well, that's going to cost you now, guys, and it costs on both sides. If a continuance is granted based on a dilatory conduct, meaning, Judge, I have been asking for the corporate representative's deposition for the last 3 months, and defense counsel just will not give me the name of a person, won't give me dates. You can ask for sanctions and the court may impose them. I think you're going to see that more and more, guys. Keep it in the back of your mind. And you're going to have to tell your clients, guys, if you just want to play this game where you're just not going to give me the name of the corporate rep or you're not going to provide me the discovery, just be advised, you may be subject to sanctions. And I'm going to be clear because I highlighted this. The court may impose sanctions on the attorney, the party, or both. I will tell you, I have done this in the past, and I've gone to court and I've specifically said, because I know the lawyer on the other side, Judge, I have no beef with counsel on this. I have called, I've gotten a response every time that says I'm waiting for my client to respond, or I have not received guidance from the defense yet. I'll let you know. And I've moved for sanctions against the party, not the attorney, and the courts have granted it. So just so you know. Question. Motion for summary judgment, not initial disclosures. We'll get to motions for summary judgment here in a minute. I know what you're talking about now. I apologize. Motions for summary judgment are huge. Give me a minute and we'll get to it. I promise. Your order on the motion to continuance is not going to be the judge saying, in the interest of justice, we're continuing this for 30 days. No, 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 no. It is going to be a written, it has to be a written order or a record finding. So the court's going to have to state, this is why I'm continuing this trial. Think about it like preserving an appellate issue. They're going to have to actually make a finding on the record, not just, okay, fine, a motion granted 30 days. I find that X, Y, or Z is a reasonable reason to continue this case. I find over defense objection or over plaintiff's objection, this is what I'm doing, and here's why I'm doing it, or a written order to grant that continuance. All right, let's get to the meat. I know you guys want to do the summary judgment stuff because it's a big deal. If you file discovery before disclosures, wouldn't you need to confer on motions for stay? Yes. I could see a judge granting the other side's fees for this. No. Because if you call me as a plaintiff because you got my discovery and you say, hey, I haven't gotten your initial disclosure, can I get a 60-day extension? And I say yes, you've resolved your issue. If I say no and you have to go to court, yes, then you very well may be asking for fees on that stuff because it's unreasonable for you to make an opposing party comply with discovery obligations if you haven't complied with your obligations first. Good question there. All right. Motions for summary judgment. Sorry, guys, I'm kind of moving this back and forth. The response time now for motions for summary judgment for all cases, now, any case, every case, as of January 1st, is your response is due no later than 60 days after the service of the motion for summary judgment, not as of the date of the hearing. So remember those 40 days from the date of the hearing stuff? Forget all that. Motion for summary judgment gets filed. By the way, you don't need to seek, you don't need to confer for dispositive motions. So motion to dismiss and motion for summary judgment don't require conferral. Clearly, the other side opposes your dismissal or your motion for summary judgment. So it's, you don't have to get conferral for that. But the minute you get one, folks, you put it on your calendar, your answer has to be filed within 60 days. If not, you're out of time. And we'll talk about why that matters. Because if you're out of time, you don't have a response. So the court can consider the defense's motion without your reply. Why is this a problem? Because under the most recent new rules dealing with summary judgment, it is your obligation now as the defending party to actually have record evidence to support your claim. And if you don't have record evidence, you know what's going to happen to you? You're going to get dismissed. All right, it's 12:45, so I'm kind of moving this as fast as I can. I'm sorry if I'm talking very quickly. Again, all of this is in my memoranda that you are all can have. Service of process. I think this is really cool. In the cases, where there are lawyers on the other side pre-suit. For me, nursing home cases, medical malpractice cases, or trucking accident cases where lawyers get involved before we file a complaint. I would always ask, are you willing to accept service of process for your client? And many times the clients would say, I don't have authority. The lawyers would say on their side, I don't have authority to do that. So you're gonna have to serve my corporate rep, or you're gonna have to serve it under normal circ. Okay, fine, whatever. And we would do that. In today's world, if you ask opposing party to accept service because you have some connection with, and they refuse to accept service, you can now ask for that service fees and the cost of the process server to be paid by the other side. So I think that that's very cool. The other good thing that you can do is, remember, everything by service had to be with certified mail by the Postal Service. And no disrespect to our friends at the Postal Service. You all know, if you've ever sent, certified mail with a little green card, how many times you get the green card back, how many times you don't get the green card back, how many times it comes back with no signature, you can't prove anything. This helps you because you can now use any interstate commercial mail carrier or delivery service. FedEx, UPS, DHL. You can use all that stuff. Delivery services, I don't know if I would use a courier, but I think I would use something that's like a parcel carrier, somebody that's licensed to deliver. I think I would use that. So you can use non-certified mail for purposes of service of process from now on, which is huge because FedEx is going to give you something back. We went, we tried, the door got open. They slammed the door in our face. I left the package at the door. Great. But the beauty about it is, if you ask opposing counsel or the party, presuming you have contact with them, to accept service they don't, you're going to be able to get your fees back. All right, question. Has the motion to dismiss time to respond changed under the new rules? The motion. Oh boy, if the motion for summary judgment was filed before the amended rule, but hearing is scheduled after the amended rule, does the prior timing apply? Yes, and I'll tell you why. Because the rule change happened after the motion before your motion for summary judgment was filed, meaning the procedure for that rule was in effect at the time. That is what you're bound by. But if I file a motion for summary judgment today, you're bound by the new rules. Has the motion to dismiss time to respond changed on the new rules? No, the motion to dismiss time has not changed. I am still one of these guys that I guess I'm terrified every minute of every day and I get sucked into the procedure. So when I get a motion to dismiss, I normally will answer it, but you're not going to get your case dismissed because I understand a lot of times defense counsel will file a motion to dismiss and it's just part of their process. And they still answer your discovery. You guys do all the stuff that you do because they never set it for hearing. But if defense counsel sets their motion for, to dismiss for hearing, old rules apply. So yeah, keep that in mind. There is no 60-day rule. That is a motion for summary judgment rule only. Got another one. If a party files a summary judgment response after the 60 days, do the rules say the judge must not consider the response, or is it up to the discretion of the judge? Great question. It says that you have no later than 60 days after the service of the motion for summary judgment. That is your time frame. I believe if you file it on day 61 and you explain to the court that you were sick, something bad happened, you were at a funeral, I don't know, something like egregiously bad, I think that there's going to be reasonableness that the courts are going to exercise. But I think that if you just didn't read the new rules and the court rules without your response, you're F, kids. I really do think that you're going to have problems in that. I suggest that if you get a motion to dismiss, and I do this a lot, call opposing counsel. Hey, is this one of those like for real ones? You're going to set it for a hearing because you honestly believe that the four corners of my pleading do not state a cause of action? If the answer is yes, I really do think that. Answer the motion to dismiss, get it set for trial, get it heard, and just keep on moving. Guys, I think you all know what I mean. Sometimes the motion to dismiss I don't want to call them frivolous because I don't want to put that on you guys, but they basically have a very simple response. Rule 1.110G allows me to plead this in the alternative, and it's going to be a denial of the motion to dismiss. Talk to your people. I'm going to tell you the truth. I am starting in my mind to contemplate whether I'm filing motions for sanctions in my responses to motions to dismiss that are flagrant and what I call the cut and paste job, where you say in your motion, and a plaintiff in their complaint did not allege this, and it's clearly there on paragraph 12. I'm going to file motions for sanctions and make saying, judge, defense has filed a motion to dismiss against me. That motion to dismiss says this. Clearly on paragraph 15 of my pleading, it says exactly what they say it doesn't say, and I'm moving for sanctions for a frivolous pleading. And I think you're going to see judges impose more sanctions as we go forward. We got about 4 minutes because I'm talking as fast as I possibly can. Um, if you have any more questions, throw them in there now. I do want to put one thing in there, and again, this probably doesn't matter to you all, but please understand these rules do not supersede the rules that are in play for chapters involving medical malpractice. So those of you that also do employment law and medical malpractice, these do not supersede your medical malpractice standards and your pre-suit requirements. That all stays the same. I'm going to go back to 1.510. The deadline for the response was changed from 60 days to 40 days on 12/5 Supreme Court order. Then a hearing must be set for a date at least 10 days after the deadline for serving the response. I'm going to read that again. The deadline for the response was changed from 60 to 40 on 12/5. Then a hearing must be set for a date at least 10 days after the deadline for serving the response. You're teaching me something new. I have not seen that has gone into effect. I'm going to have to go look at that. If that is in fact a change, clearly it's going to make a big difference if you go from 60 to 40 days. I'm going to have to look at that and kind of report back, because even though the Supreme Court can change the rule, there's a notice provision and all that great stuff that has to happen. Can the 60-day response time under the summary judgment be enlarged for good cause? Yes, I think it can. And I think one of the things you're going to have to do is file a motion. Call your opposing counsel, say, hey, I'm going to be out of the country in the time frame that your motion, that this response is going to be due. Can I get an extension? Yes, you can. Unopposed motion to extend time for this, response motion summary judgment. Defense counsel will be out of the country, or plaintiff's counsel will be out of the country until this day. Counsel is conferred with opposing counsel and have an agreement to extend that deadline pursuant to agreement. Ask the court for an extension, obviously as quickly as you can, because you're going to need to get that order before your deadline is extended. Meaning, if you don't have that order extending your deadline, you don't have a deadline extension, because you cannot extend the deadlines without a court order. Just know about that. Can you clarify when you can use UPS or FedEx for service of process? Is that for initial service in all cases? No. Your initial service of process of the complaint is still by process server. But you know how and I have to say that I don't do a lot of employment law. So when you have to serve notice to another side and you use certified mail, if you have to provide like service of notice requirements, for example, you did not answer the complaint. Therefore, I have to serve you with notice that there's going to be a motion for default, or I am going to go forward on a judgment. You have to serve the opposing side. You can now do that through an interstate commercial carrier or postal service with a tracking number. You're not stuck by U.S. certified mail. Your initial pleadings still have to be served by process service, unless your opposing counsel is going to accept service. If they don't, and they make you serve, you're then going to ask the judge and the court to give you that money that they owe you for the cost associated with that service of process. I hope that answers that question. I am going to go back and take a look at that Supreme Court. I'm going to give it to everybody. Supreme Court Order 2024-0662. I have to go read it and see if it's actually in play. Apparently, it changes the response time on the motion for summary judgment from 60 days to 40 days. Obviously, it's 20 days difference. So it's kind of a big deal, guys. So maybe while we're talking about it, this may be a good time for you all to go look at that too. If I find that that is a huge deal, I will notify Michelle and Amy and get you all something that says that that is going to affect you all. So I'm not giving you bad information. Whoever put that up there, thank you for that. I appreciate you having the wherewithal to put that in my eyes to make sure that we're not giving people bad intel. It is 12:55, and I'm happy to keep talking because, as you can tell, I love to hear myself talk. If you have questions about this stuff, call me. Pete Sartes is my name. I do personal injury at Tragos, Sartes and Tragos in Clearwater. I'm not hard to find. I'm pretty easygoing. Shoot me a call. or shoot me an email. I'm happy to talk to any one of you guys. At the end of the day, we're all in this business of litigation together. And if I can help you, think something through, I'm happy to do it. Likewise, you have my memoranda. Do with it as you will. Share it. Use it how you want. I put this out there for your benefits. I'm going to put out the, help me out here, the, what do they call it? The CLE for your credit. Is the CLE for credit 8901, Michelle?
It is, yep, 8901.
So for all of you, when you're going to put in for your continuing education, 8901 is a CLE number.
If you want to stay on and answer a few more questions, I think
Sure.
do that. I know some people are going to have to go, but if you want, I know there were a lot of questions.
No, this is great. This is great.
I'm going to do a little more. Amy will correct me if I'm wrong, but usually we can go over past 1 o'clock a little bit.
I don't mind. Let me just check my calendar real quick. I don't believe I have anything that is keeping me from doing that for another half an hour. So we're in good shape. Let me just get back to those questions. Yes, I am going to report back on the date of the Supreme Court change, presuming it's taken effect. Normally, guys, even when the Supreme Court signs something making it from 60 to 40, that there's a notice time. You can't just sign the order today and it's in effect today, because obviously we all don't know about it. So they normally have to publish that notice, and let me take a look at it and I'll get back to you all. What I'll probably do is look it up when we have a minute to actually to think about it. I'll do that this afternoon, and I'll write up a blurb if in fact it is the change, and I will get it to Amy, who will then disseminate it to all of you, which is great because I will update my memorandum. What other questions do you all have? If you have them, throw them in the chat, because as I'm looking at what's in here now, I think I have answered all the questions so far. If I haven't answered your question, just throw me a quick notice so I know. What else we got? Let's see.
There's like 2 more that just came in. Can you see
Uh,
them?
If a suit is filed in 2024 and then you amend and add a party, does that fall under 24 rules or no initial disclosures? Okay. If you filed the lawsuit in 2024, as of January 1st of 2025, the new civil rules take effect, which means now you have the obligations to update discovery as information comes into play and all that stuff. If you add a party in 2025, all the civil rules of 2025 apply. Understand that rules are procedural. That's why they're called the civil rules of procedure, meaning that whatever's in effect at the time that things are happening is what is going to, your case is going to be bound by, as opposed to the substantive rules, meaning if a statute changes after you file your lawsuit, they don't change your burden. Your statute was in effect at the time of your lawsuit, or at the time where your case accrued. That's going to be taken into consideration. But the 2025 rules are the rules now, guys. So even if you have old cases, start thinking these are the new rules for all of your cases going back. So just kind of think about this. The only caveat is like for motions for summary judgment. If the motion for summary judgment was filed before the rule took effect, you're not bound by the 40 days or 60 days because, well, the motion's already been filed, so they can't change your deadline in the midst of the process. In federal court, motions often get decided without a hearing, and judges often rule on uncontested and sometimes even contested matters within a day or two, sometimes hours. Darn right. Judicial delays are usually not the reason the case gets delayed. In state courts, not so much. True, because most state court judges will not rule on contested motions at a hearing, a motion to dismiss, or a motion to compel, and timely hearings can be hard to get. All true. I am concerned that with more active case management, whoa, I lost you, hold on. I'm confirmed more active case management, judges, sorry, as I'm reading, I'm getting more notes, so it's kind of jumping around. Can be hard to motion. Okay, I am concerned that with more state court judges will not rule on contested motion at a hearing, motion to dismiss, or motion to compel, and timely hearings are going to be hard to get. I am concerned that with more active case management, gosh, it's jumping around, guys. I am so sorry. I do share that concern. Basically, what you're saying is in federal court, judges are moving like this because they got 10 law clerks looking at this stuff, figuring out if there is a way to get rid of something, and they do it. A number of jurisdictions are bringing on board general masters, think of them as magistrates, that I think are going to deal with this stuff. Some of our jurisdictions that are not doing masters are putting in local rules that allow for the determination of things like this on the pleadings. And if you invoke your local rules, for example, in the 6th Judicial Circuit, Pinellas and Pasco, we actually have a local rule that if you invoke it you're basically telling the other side, I am asking the judge to consider this on the pleadings. And the judge will look at it. And if they can do it on the pleadings, that's fine. If they need a hearing, then they'll set a hearing. Guys, my biggest problem is this with these rules. I know what we're trying to do, and we're trying to streamline the process, take things out of the court's hands, make the parties confer better so we can streamline the process. But there's a reality. If if you're obligated, like you are, to set your trial in 18 months and you do everything right, you're still going to show up at your pretrial conference and the judge is going to tell you that you're number 34 in line. So what are you going to do? It's going to be a problem no matter how we look at it, because now you're going to have to update your records, update your bills, update your disclosures for your experts. All that stuff's going to keep on going. So I think for a practical effect, we're not going to get to the system any faster, at least for now, because there's a lot still on the docket post-COVID, right? But I think if we all get used to functioning this way, it can become the more genteel practice that we had pre, help me out, pre-COVID years. So I'm hoping that, we're able to get a lot of this stuff done. And, as you start getting orders from judges, how a particular judge is going to order on a particular issue. So you already know where it's going to go. And you can put that in your motion and say, I conferred with opposing counsel, told them how the court usually rules. They said, go pound sand, judge, I need you to make an order. And I am moving for sanctions because we all know this is the way you always rule. Something like that. Don't be afraid to use that stuff. Realistically, are these judges who will ignore these changes? Oh, no. There are not going to be judges that are going to ignore these changes because the senior judges the burden is put on them, not the senior judges, excuse me. The chief judges have the burden of putting this all into play. So it is now the new way of doing business for all of us. I truly believe that the judges are going to take this seriously because I think they think that in the long run, it is going to help them. What they're going to do is probably not grant your continuances and force you to do things within the time frame set forth by your case management order. So I think they're just going to say, nope, I'm not hearing that. Your problem, like the federal judges do. Let's see. What is the motion to dismiss deadline? There really isn't a motion to dismiss deadline. If somebody files a motion to dismiss, you're really supposed to, you're supposed to set a hearing and get it determined, get a determination made. But a lot of us in the course of our practice, you see it all the time. Somebody files a motion to dismiss, and frankly, you don't deal with it until like you're in 6 months worth of litigation. I don't let that happen. I actually will get this stuff set. I'll get it responded to, and I'll get it done as quickly as I can, so we don't have any loose ends. And that's just me because I like pushing my cases quickly. I like getting things done fast because I think it gives my practice a cadence that helps me settle or get cases resolved. Because the defense lawyers talk to their carriers like, look, this guy ain't playing. I'm going to file this BS motion you want me to file, and he's going to file a response to it within 2 days. He's going to ask me to set it for hearing. He's going to move for sanctions because it's a BS motion, and the judge ain't going to like that. That's what I'm doing. Take it for what you will. There really is, not that I'm aware of, any actual deadline change in the new rules for motions to dismiss. And again, you don't have to confer for those because it's dispositive. What were citations for Supreme Court order? Yes, I will do that to you one more time. The citation is Supreme Court 2024-0662. So that's Supreme Court orders 2024-0662, and that is for summary judgment. Let's make sure I'm not missing anything here.
We have a Westlaw site for it too.
Ooh, I love it.
We
That's what I'm
provided
talking about, guys.
2024 Westlaw 4982906. So
And I do see the corrected opinion. You got it.
Yep,
There's
so
also a corrected opinion on the Florida bar.
Okay, so 2024 Westlaw 4982906. I cannot message everybody, otherwise I would. And I know Amy had to step out, so hopefully everyone can find it.
I got it, and I'll do an update because it looks like we have a corrected opinion on that. So I will take a look at it. I'll look at it, guys. Don't worry, I'll get this back to you so we are confirmed on the 40 days versus 60 days. Whoever brought that up, thank you. That's a big deal, and I appreciate you for that. What else we got, guys?
See
if I can open this up.
See one more. Oh, it's just another update on that opinion. So yeah, I
Another
don't know that we have
update.
any more questions.
Yeah, I'll stick around for a couple more seconds if anybody's got any questions. So I'm going to actually cut and paste, and I'm going to put it in your view because you guys can still see me. Here is the
Ah,
comment. Here we go. Let's make this bigger. So 1510, deadline for the response was changed from 60 to 40 on 12/5. There's the Supreme Court order. And I don't know if anybody can actually see this. Right below, I put the media from the Florida Supreme Court talking about the corrected opinion. So that is awesome. And I will get that reviewed this afternoon, and we'll get that to you all to make sure we're all on the same sheet of music. One of the great things about common law, right? The law is in a constant state of flux. Everything changes, why it's so hard for us to do what it is that we do.
yep. Well, I don't see any more questions. So
Awesome.
I think we'll conclude this. Thank you so much, Pete, for doing this for us. I know people are very interested in this topic and how it's going to play out. And I could see by the engagement that people are trying to figure this out. So
Yep.
I appreciate your expertise here, and we will see everybody next month, February 19th, for the next webinar. All right. So have a nice day, everybody. I don't know that I can close this, but I'm gonna try.